Hi everyone, welcome to Lawyer Up by NDV Law. I'm attorney Karlo Nicolas, a senior partner of Nicolas and the Vega law offices. Today, we are going to discuss when a person becomes liable for the crime of cyber libel. Let's take a closer look at the law on cyber libel and the liability imposed under the law to determine whether a person posting, sharing, commenting, or liking a libelous post in social media is liable for the crime of cyber libel. We have to explore the principal acts amounting to the crime of cyber libel itself, as defined under the Cybercrime Prevention Act of 2012. When the Cybercrime Prevention Act of 2012 punishes the crime of cyber libel, it makes reference to Article 355 of the Revised Penal Code and punishes the same set of acts defined under the Revised Penal Code, but outlines its commission through a computer system or any other similar means which may be devised in the future. Proceeding from the definition of libel under Article 353 of the Revised Penal Code, cyber libel is defined as a public and malicious imputation of a crime, vice, or defect, real or imaginary, or any act, commission, condition, status, or circumstance tending to cause dishonor, discredit, or contempt of a natural or juridical person or to blacken the memory of one who is already dead, and committed through the use of a computer system or any other similar means which may be devised in the future. Let's now discuss the elements of the crime. The following are the elements of the crime of cyber libel based on Section 4 of RA 10175 in relation to Articles 353 and 355 of the Revised Penal Code. First, there must be an imputation of a crime or of a vice or defect, real or imaginary, or any act, commission, condition, status, or circumstance. Second, the imputation must be made publicly, which requires at least that one other person must have seen the libelous post, in addition to the author and the person defamed or alluded to in the post. Third, the imputation must be malicious, which means that the author of the libelous post made such post with the knowledge that it was false or with reckless disregard as to the truth or falsity thereof. Fourth, the imputation must be directed at a natural or juridical person or one who is dead, but which requires that the post must at least identify the person defamed, or at the very least, the person defamed is identifiable by a third person. Fifth, the imputation must tend to cause the dishonor, discredit, or contempt of the person defamed. And finally, the imputation was done through the use of a computer system or any other similar means which may be devised in the future. Let's discuss who are liable for cyber libel. It must be noted that the revised penal code punishes the person who shall publish, exhibit, or cause the publication or exhibition of a libelous post, or the editor or business manager of a book, pamphlet, magazine, newspaper, or serial publication containing the libelous material. Therefore, and in relation to the cybercrime of cyber libel, you have two personalities that are clearly subjected to liability. The first is the author of the libelous post, which includes the person who shall publish, exhibit, or cause the publication or exhibition of the libelous post. The person who created the libelous post would, of course, fall under this category. Second, the editor or business manager, in case the libelous post is contained in a book, pamphlet, newspaper, magazine, or serial publication. What is the penalty for cyber libel? Traditional libel is punished under the Revised Penal Code as amended by the recent Republic Act number 10951 and is committed by means of writing, printing, lithography, engraving, radio, phonograph, painting, theatrical exhibition, cinematographic exhibition, or any other similar means, and shall be punished by prisión correccional in its minimum and medium periods, or a fine ranging from 40,000 pesos to 1,200,000 pesos or both, in addition to civil actions which may be brought by the offended party. The penalty under prison correctional in its minimum involved imprisonment from 6 months and 1 day up to 2 years and 4 months. On the other hand, prison correctional in its medium period involved imprisonment from 2 years, 4 months, and 1 day to 4 years. Thus, the computation of periods for penalties under the revised penal code, the penalty imposed for traditional libel involves imprisonment from 6 months and 1 day to 4 years and 2 months. On the other hand, the Cybercrime Prevention Act of 2012 punishes the crime of cyber libel with a penalty 1 degree higher than that provided for by the revised penal code. And since the crime of traditional libel is punished under the revised penal code and under the Cybercrime Prevention Act, if the crime is cyber libel, the penalty to be imposed shall be 1 degree higher than that provided by the revised penal code as amended. The penalty imposed would be prisión correctional in its maximum period to prisión mayor in its minimum period. Prisión correctional in its maximum period involve imprisonment ranging from 4 years, 2 months, and 1 day to 6 years. On the other hand, prisión mayor in its minimum period involve imprisonment from 6 years and 1 day up to 8 years. Thus, the penalty based on the penalty under the revised penal code for traditional libel and computed under Section 6 of the Cybercrime Prevention Act of 2012, which increased the penalty by 1 degree higher, is 4 years, 2 months, and 1 day up to 8 years. We have now discussed about cyber libel, its penalties, and when a person becomes liable for the crime of cyber libel. You can also visit our Facebook page and our website, ndvlaw.com, for a wealth of legal resources. Now, if you found this video helpful, please subscribe to our YouTube channel. Again, this is Attorney Karlo Nicolas of Nicolas and the Vega Law Offices, and thank you for watching Lawyer Up by NDV Law.